Hello, and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law section of the American Bar Association. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law. It's also our way of bringing the section's expertise out from behind the paywall and into the commons for a public curious about these topics to discuss and debate. Each episode is presented by one of the specialty committees within the section. This episode, produced and co-hosted by the Privacy and Information Security Committee of the Antitrust Law section. Today's episode is a look back at 25 years of privacy enforcement by the U.S. Federal Trade Commission. The word privacy doesn't appear in the Federal Trade Commission Act. The FTC's primary legal authority over privacy comes from Section 5 of the FTC Act, which prohibits unfair or deceptive acts and practices. On the one hand, this relative paucity of words affords the agency a certain nimbleness and flexibility that has enabled it to quickly pivot to emerging technologies and new business practices without a specific act of Congress each time. On the other hand, there are no specific definitions of what behavior is prohibited other than unfair or deceptive acts and practices. The FTC brought its first privacy cases a quarter century ago, starting with the GeoCities case back in 1998. GeoCities, for our digital native listeners too young to remember, was a prehistoric social network. It organized into communities that were filled with user-generated content. GeoCities collected a considerable amount of personal information from its users, but, according to the FTC, misrepresented what it was doing with user data, how it was collecting data about children who were using the site, and how that information was being shared with third parties. All of which, according to a first-of-its-kind complaint filed in the Triassic era of the Internet, amounted to deceptive practices in violation of the FTC Act. In time, the focus of the FTC's enforcement moved beyond accuracy and completeness of disclosed privacy policies to specific security practices in violation of Section 5. In time, the focus of the FTC's enforcement moved beyond accuracy and completeness of disclosed privacy policies to specific security practices in violation of Section 5. In the early 2000s, the FTC focused its enforcement on data security, first alleging that certain security practices were deceptive, and then, starting in 2005, alleging that certain security practices were unfair. Since the passage of the FTC Act, the FTC's authority has been expanded by Congress to enforce a variety of sector-specific laws, including Gramm-Leach-Bliley, the Truth in Lending Act, CAN-SPAM, the Children's Online Privacy Protection Act, the Equal Credit Opportunity Act, the Fair Credit Reporting Act, and others. The FTC has also buttressed its enforcement authority through its own rulemaking processes. Now, the FTC's track record as a privacy enforcer has drawn criticism from both corners. From those who think that the Commission is doing too little, particularly with respect to the collection and use of data about what people do online, and from those who think that the Commission is reinterpreting the scope of its authority beyond what Congress ever intended. Today, we're going to take a look back at the first 25 years of privacy enforcement by the FTC. What has remained the same? What has changed, and what lies ahead? Indeed, in a world where the threats to privacy have grown manifold, has the Commission stretched the handful of words passed by Congress in 1938 as far as they can? And is it time for a new agency empowered with fit-to-purpose authority to take the baton for the next 25? Now, I couldn't have drawn up a better collection of guests to discuss that topic here today. The panel we have for this episode captures the full lineage of the FTC's first 25 years of privacy enforcement. Joining me today are Daniel Kaufman, a partner at BakerHostetler. Daniel spent over a decade as Deputy Director of the Federal Trade Commission's Bureau of Consumer Protection and also served as Acting Director, BCP. We also have Maneesha Mithal, a partner at Wilson, Sonsini, Goodrich, and Rosati. Prior to joining Wilson, Maneesha spent over a decade leading the Division of Privacy and Identity Protection within the FTC's Bureau of Consumer Protection. And last but not least, we have Sam Levine, the Director of the FTC's Bureau of Consumer Protection. He previously served as an attorney advisor to then Commissioner and now Director of the Consumer Financial Protection Bureau, Rohit Chopra. Prior to joining the FTC, Sam worked in the office of the Illinois Attorney General, prosecuting predatory for-profit colleges. Maneesha, Sam, Daniel, welcome.
It's great to be here.
Daniel, let's start with you. What is the scope of the FTC's authority over privacy?
So I think you laid it out really well in your introduction. And when you back up, if you were creating a privacy agency today from scratch, these are not the tools you would give the agency. Deception and unfairness are tools that were designed and used a lot to build the advertising program. But the FTC is a creative agency and used those tools and used them quite cleverly to implement a privacy program in the late 90s, first with deception, then with unfairness, and really did quite a lot given the tools that they have. You also mentioned a few of the other tools, whether it's Fair Credit Reporting Act, COPPA, GLB, but I think there are two other things that I would also flag as important elements of the FTC's authority. One is the 6B authority that allows the FTC to collect information and report on it. That has been a really important tool that the FTC has used in the privacy arena. And also, of course, you touched upon Section 18 and MAGMOS, and we're seeing certainly a lot of activity at the FTC now using that tool. So again, they've got a range of tools, but are they designed for a privacy agency in 2023? I think that is definitely an open question.
Now, one thing that surprises some of our foreign colleagues when they hear about this is that compare the FTC's resources to other countries. In the United Kingdom, their Information Commissioner's Office has 700 staff, a dedicated budget, and bespoke laws for a country of 70 or so million people. Whereas the FTC total has 1,100 employees, only 30 to 50 of whom are in charge of privacy enforcement for a country of 300 million. That to me is just staggering how much the FTC has to do with relatively so little.
Yeah, I would just agree with that statement. I think that there is probably bipartisan support for the concept that the FTC is under-resourced and understaffed. And I think we've seen some bills that would give the FTC additional authority in the privacy area, but as we've seen, those have not passed. And so the FTC has been continued over the 25 years to be forced to do more with less. I think it's been remarkably creative in doing so.
So let's talk about the FTC's scope of authority under Section 5. Section 5 doesn't enumerate specific rights or prohibit specific practices. Is it fair to say that Section 5 limits the FTC's authority to policing whatever privacy commitments that companies have voluntarily made to their own customers?
I would say that the FTC authority does go beyond that. And I think the FTC has been aggressive in bringing cases under the unfairness prong of its authority. I think the criticism has been, well, if a company doesn't say something about their privacy policies, the FTC can't really do anything. So that's the deception prong. So if a company makes a misrepresentation about how it's going to collect, use, or share data, that's clearly a Section 5 violation if that misrepresentation is material. But I think the FTC was a little bit reluctant to use its unfairness authority in the early years of the privacy program. But I think, as you mentioned in your opening, starting in 2005, the FTC began to use its unfairness authority to allege that first, unreasonable security practices were unfair. And then second, as the years went on, the collection, use, and disclosure of sensitive information like health information, TV viewing information, geolocation information, that the collection, use, and disclosure of that information without reasonable safeguards and without notice and consent is unfair. So I think it's the unfairness prong that's really evolved over the last 25 years. And the FTC has really done more with that, culminating in today where the FTC is aggressively using the unfairness authority to really push the bounds of what it's done before.
And I think another thing that might be useful for some of our listeners to keep in mind is that there is no constitutional right to privacy in the U.S. There are some judicial constructs, but you should compare it to Europe, which does have concepts of a right to be left alone, which has led to a right to be forgotten. The FTC is working with a different set of laws than some of our listeners may be used to in other parts of the world. Let me ask you about fining authority. Under Section 5, there is no fining authority for first-time offenses, is there?
That's right.
After the first offense, the FCC has to enter a consent agreement with the company. And then only if the company violates that settlement agreement does the FTC have the ability to come in and issue a fine. Do I have that right? You can't get them the first time. It has to be the second time or later?
Yeah, I think that's generally true under Section 5. That you have to have a first-time violation and then you can get civil penalties for order violations. But I do think that the FTC, actually, let me put aside other laws. So the other laws you mentioned, Fair Credit Reporting Act, Children's Online Privacy Protection Act, the FTC can get penalties for first-time violations. But in terms of Section 5 violations, I think that the FTC has really been creative on two fronts in fashioning remedies. I think the first front is on monetary remedies. For example, the FTC has recently partnered with states to get monetary remedies under state laws. The FTC has used additional tools under Section 5, which I know Sam can talk about, to get additional monetary penalties. But I think the FTC has also been aggressive in trying to deter companies from violating Section 5 through non-monetary penalties. Things like naming individual officers as liable for Section 5 violations, requiring things like algorithmic disgorgement. So if a company makes a misrepresentation about how it's used data, not only requiring companies to delete that data, but to delete the algorithms that came from that data. So in that way, the FTC is really trying to find additional sticks, so to speak, to make sure to deter unfair and deceptive practices, given the fact that they don't have first-time finding authority under Section 5.
Under Section 5, does the FTC have to quantify a harm to consumers or someone else, or are these unfair, deceptive, active practices themselves a violation of Section 5?
Yeah, so I think your question gets at the parameters of unfairness. So unfairness, basically you have to prove three things in order to prove an unfairness violation. First, the act or practice has to cause or be substantially likely to cause injury to consumers. Second, that injury can't be outweighed by benefits to consumers and competition. And third, the injury can't be reasonably avoidable by consumers. So there's been a lot of discussion and focus over that first injury prong. And back in the early days of the program, the injury was mostly thought of as financial injury. So has your credit card been stolen? Are you a victim of identity theft? And that's why the early focus of the program was on deceptive and unfair security practices. Then as we went on, there was a recognition that there can be reputational injury and other types of injury when your privacy is violated. And that those claims were tested in litigation in the 2010s through the Wyndham case and the LabMD case. And I think today there's a broad recognition that the injury can be intangible, so to speak. So it could be reputational injury. But I think there's still some discussion, some litigation around that issue. There's the ongoing Kuchaba case, which Sam and others may be able to talk about. But I think your question gets at what is the nature of the injury that is cognizable. And that's an issue that I think will remain to be fought in the courts.
Let's get into that arc of the FTC's history and its litigation. Maneesha, how did the FTC's privacy enforcement program begin?
Yeah, so I think you laid it out really well in your opening with the GeoCities case. I think there was this recognition that the FTC had this tool, unfair deceptive practices, that had been used for fraudulent newspaper ads or telemarketing fraud or infomercials. And then in the 90s, this new thing came about, the internet. And people began to be concerned about sharing their personal information online. And so the FTC pivoted and started looking at internet privacy. And then the FTC did 3 reports to Congress in the late 90s, early 2000s, culminating in the report where the FTC for the first time recommended internet privacy legislation. So then that was the early 2000s. Then a Republican administration came in, and there was a concern that under the new administration, the privacy program might be diminished or pushed back. But I think that concern was not well-founded. In fact, the Republican administration that came in had a huge positive agenda on privacy, wanting to focus on things like data security cases, the Do Not Call registry, the Fair Credit Reporting Act, the Children's Online Privacy Protection Act. And there really was a robust privacy enforcement program. And so I think that shows that there's really bipartisan support for the idea that the FTC needs to be a cop on the beat in terms of privacy enforcement. And that's continued to this day.
Which is surprising because if you go back a little bit, 15 or 20 years earlier, the FTC's consumer protection arm was heavily criticized from both parties for having gone too far with some of their attempts to rein in children's advertising. I'd love to hear from Sam or Daniel about how you think that the program has evolved, or which is some of the maybe continuing fault lines between Republicans and Democrats on the privacy enforcement.
So look, from my perspective, privacy is one of the few bipartisan issues that are out there. On both sides of the aisle are very supportive of privacy enforcement, privacy legislation. There's just an inability to get broad privacy federal legislation to the finish line. So I actually think it's an area where there is unique bipartisan support. I think there are some fault lines. I think there are some questions being raised about some of the approaches the FTC is currently taking. But I do think those are at the edges. I think at the core, there is certainly a significant push for federal privacy legislation that would strengthen the FTC and give it better tools to navigate challenging issues in 2023.
And I agree with that completely.
Okay, someone finish the sentence for me. The FTC's privacy enforcement has become increasingly blank.
Unpredictable. I think
Maneesha?
that's...
Oh, sorry, Daniel. Keep going.
Look, unpredictable, I would say, and that is the concern that I'm hearing from companies. And part of it goes to the use of unfairness as a tool. It is a tool that's inherently vague. It's a 3-part test. How do you meet it? What are the practices that can be deemed unfair? So that uncertainty is the criticism I hear mostly from companies I work with.
So I would say the FTC's privacy enforcement is increasingly aggressive. I think I would agree with everything Daniel and Sam said about the bipartisan support for privacy enforcement generally. I think that the fault lines, so to speak, lie around maybe the idea of proportionality. When should individuals be named? When should algorithms be disgorged? And just to give you an example, for naming individuals, I think a concern may be that unless the individual had actual knowledge or was deeply involved in the violent practices, if you name people like chief privacy officers or chief information security officers in privacy cases, are you going to then create disincentives for really good people to be in those positions? On algorithmic disgorgement, I think there's a fault line around when to disgorge algorithms. For example, if there's a product that consumers love and you're going to make companies go back to the drawing board over a deceptive statement that may be tainted 0.1% of the algorithm, is that something that the FTC should be doing? So I think those are the types of things that there's some fault lines among Republicans and Democrats. There's some fault lines around industry groups and consumer groups, I think, is that sense of proportionality.
So I'm happy to jump in on some of the issues that both Daniel and Maneesha raised. I agree that there are issues that people have raised around predictability, individual liability, and the like. Starting with predictability, I think the FTC has a long tradition of really clear, outstanding business guidance that is very much continued in this administration. We issued business guidance in, I think, the summer of 2022, making clear our concerns with the indiscriminate sharing of health data. We followed up with that guidance with enforcement actions. And by the way, that guidance is consistent with warnings the FTC has been putting out for many years. We put out a policy statement on education technology that talked about some dimensions of COPPA, like Section 312.7, that don't get as much attention. That put the market on notice around our concerns. And once again, we followed that up with enforcement actions. I gave a speech a couple of weeks ago to Consumer Data Industry Association around some of the specific concerns the FTC had with data brokers and laying out steps data brokers should take to ensure they can stay on the right side of the law. So business guidance, I think, is absolutely critical to the work we do. And this guidance can take the form of our outstanding blog series, also policy statements that the Commission is articulating its position. One of my messages to industry is pay attention to what we're saying. We do follow up. On the last point about individual liability, I think there's been an important shift here. In the Drizzly matter last year, which was a data security matter, we alleged about the company and its CEO engaged in unfair data security practices. And the complaint named them both, and the order found them both. And one of the messages I hope that sent is that security is a C-suite responsibility. You know, the FTC has been saying for many years, start with security. That's been our business guidance. But what we know is that many, especially at startups, but we see this across the board, companies can tend to underinvest in data security. Often it's not a very attractive investment when they could shift resources to marketing or new products or other pursuits. We want to be really clear that ensuring a company's data is protected, especially sensitive data, is a responsibility that starts at the top. And I think that's an important message we've been sending through enforcement action. So we certainly take these criticisms seriously, and we are always an open door, and I'm always happy to engage with business, but we take pride in the guidance we put out. And my message has been consistent. When we say we're going to do something, we tend to follow up.
I think that's a great point. And I think Sam articulated it very well. I think that I think the kind of criticism is generally that if you combine those 2 points, I think the FTC does provide a lot of guidance and transparency on kind of practices that it will consider unfair and deceptive, areas that it will focus on. And I think that I think the criticism is that sometimes where that transparency may be lacking is in individual enforcement decisions and that proportionality basis. For example, the facts of the complaint are the only thing that are public in a decision as to whether to name individuals. And so I think there's a concern that is there behind the scenes proportionality? What is the guidance? What should CPOs and data protection officers be doing? I think there are companies that spend lots of money and pay a lot of attention to privacy and security, and they may get something wrong. And so I think that's just the kind of the criticism and the back and forth. But at the same time, I will say that I think there's a lot of consensus and there's a lot of through lines running through the 25 years of privacy enforcement. So the idea that collection, use, and disclosure of sensitive health data without safeguards and without notice and consent, that those cases, there were cases that were brought in the early 2000s, in the mid 2000s involving health data. And so I think in terms of unfairness, I think there's been a lot of consistency. I think the FTC is being very creative now and aggressive, but I think that has its seeds in what's been done over the last 25 years. I think what is most new is the remedies. And then you touched on this, Anant, the use of the rulemaking process, the Magnuson-Moss rulemaking process. So just historically, back in the 70s, the FTC was doing a lot of rulemakings. There were concerns that the FTC was overstepping. You made that point with respect to kids advertising and the brouhaha that surrounded that. So additional guardrails were placed on the FTC's Magnuson-Moss rulemaking authority, and it was little used for the last 25 years. Now the FTC is using that more and more. And I do think you're seeing some more dissents, particularly on the privacy side, about Republicans saying this is the appropriate role of Congress. Is the FTC overstepping its authority? So I think bottom line is that enforcement wise, there's a lot of consensus. I think that there are fault lines around remedies and there's fault lines around rulemakings.
Daniel, let me bring you in to this. What are the words that Sam said was consistency, and Maneesha laid out some ways that the enforcement has been consistent, some of the ways has changed. What are your thoughts? What stayed the same? What's different?
Yeah, look, the same issues are being discussed that were discussed for decades. How is information collected, used, shared? What information do people have about that? Are there limitations that should be put in on some of those issues? And so the issues are the same. The technology is far more complicated. The issues are far more nuanced. The uses are broader. The issues are fundamentally the same, but the ecosystem is so much more complicated. That's how I look at it. You raised this at the beginning. At some point in time, is deception and unfairness just not going to be sufficient tools to address the complicated environment we have in 2023? And I think we're probably saying the same thing 10 years ago. Is the world getting too complicated 10 years ago for deception and unfairness? And the FTC was still able to make a go at it. But I do think that is a legitimate question to ask. Like, how far can you take these tools? Because unfairness is a difficult tool. Although the FTC got a really interesting and helpful decision initially in the Kochava case, where the FTC was alleging it was an unfair practice to sell or share certain amounts of geodata. You look at the decision and you realize the decision is also saying unfairness is really hard to prove. So on the one hand, the court acknowledges that privacy violations can be an unfair practice, which is a really significant development for the FTC. But it's also saying unfairness is difficult. So there is a little bit of a tension there between the FTC pushing forward a somewhat aggressive unfairness agenda with a decision like Kochava that really highlights unfairness is not easy. Deception a little bit easier, but unfairness is complicated and it's messy.
Look, I certainly agree with Daniel on that. I don't want to comment on specific litigation, but I certainly agree with the general contours of what Daniel said. I'll make a brief observation about rulemaking. I think Maneesha and you and Anant referenced the challenges, shall we say, that the FTC encountered in the late 70s with what we know in these halls as KidVid. There has been some controversy about FTC rulemaking, but one of the things I like to remind people is that this isn't something that was made up in the last couple of years. In the early 1970s, the reason it's called Mag-Moss rulemaking is because Congress passed legislation that gave the FTC explicit authority to issue rules. The FTC had issued quasi-rules before that in the 50s and 60s. But in the 70s, the Congress actually consciously strengthened the FTC's authority to write rules laying out its view and prohibiting unfair or deceptive practices and strengthening the FTC's remedial toolkit on the back end to enforce those rules. It is true that for many decades post 1980, the FTC, with very rare exceptions, declined to exercise that authority. But it puzzles me that there's so much debate on should the FTC do rulemaking or should the FTC not do rulemaking. Rulemaking is one tool that we have. Maneesha referenced and Daniel referenced a number of other tools we have. I think debates on whether individual rulemakings are merited make a lot of sense, and we should have that debate. But I do find it puzzling, this question of should we be doing rulemaking generally, when again, this is just a tool. Congress is very explicit, not only in giving us, but in strengthening our ability to issue those rules. There's no question we have authority to issue rules. Debates around the merits of each rule make a lot of sense, but I think it's important to remember the background.
Actually, if I could just add to that, I think the other kind of debate has surrounded on rulemaking, particularly the privacy rulemaking, which is so vast with so many questions. I think that there's a debate surrounding that, and we alluded to the limited resources of the FTC. And so I think there's some concerns, and these were expressed in some of the dissents, about the trade-offs between rulemaking and enforcement. Is there a value to having a general broad strokes rule that would take years and a lot of resources, and we're not sure where it's going to end up, versus a narrower rule versus more enforcement? And so these are trade-offs that people at the FTC and SAM have to make every day. And those are not easy trade-offs. And I agree that there's a lot of tools, and the FTC has to think about how to calibrate those tools and which tools to use for which problems and when. And I think there's a little bit of disagreement around that, but I think the FTC is doing a great job of looking at the statute, looking at the tools it has, and being creative in using all those tools, while Congress is continuing to consider additional tools and federal privacy legislation.
And just a quick point on that. I could not agree more with what Maneesha said. We have not stopped calling on Congress to pass privacy legislation. I said it when we issued our advanced notice of rulemaking. Congress can move faster. Congress can pass broader rules. Congress is in the best position to protect Americans' privacy. And to a commissioner, there's agreement that Congress should do so. We are looking at all of our tools. I need to reiterate that here, but I do want to make the point that our view has not changed. Congress should pass comprehensive legislation.
Yeah, it's funny, Sam. I sometimes wonder, the commission's been pushing for that quite aggressively, but has in some respects the success of the agency over the past few decades on putting together a really robust privacy program for many years, I feel like it was taking pressure off Congress from it. The FTC had we got this mentality. They were pushing for mainly data security legislation for a while and privacy, but I've often wondered if in some ways the FTC was a little bit of a victim of its own success. They were patching this together and succeeding and suing some of the largest companies in the world and getting tremendous settlements. And did Congress feel the need and the pressure 5 years ago to pass comprehensive privacy legislation?
I think it's a great question. I think I will say as a first point, I think there are other reasons Congress has not been able to pass legislation having nothing to do with the FTC and having nothing to do with privacy. There's just a general inability to pass legislation. If anything, Congress has come a lot closer on privacy than in other areas of urgent national concern. The other point I'll just make briefly is it is true. I think we've really punched above our weight. I think the three of us are going to be in violent agreement on that. As an agency, given we're still relying on this tool from 1938, our Unfair Deceptive Practices Authority. That said, one of the things I have tried to do and Chair Khan has tried to do over the last couple of years is also make clear that we are seeing serious problems. We're proud of our enforcement track record. We're proud of what we're doing to protect Americans' privacy, but we see serious problems. We laid a lot of them out in our advanced notice of proposed rulemaking. Serious problems with the notice and consent regime. Serious problems with how people's health data is being handled. serious problems with how some data brokers are handling those data, and on and on. So we want to be really clear with Congress that while we're proud of our enforcement record and we're going to keep at it, more needs to be done, and they have the best tools.
Daniel, you talked a little bit about the evolution of what the commission considers an unfair practice with respect to privacy. I'd like to focus a little bit now on remedies. And Maneesha, you've touched on this, but I'd like to hear from this group because FTC Chair Lina Khan has been focusing quite a bit on remedies. Can you discuss the evolution of remedies in privacy cases and what are the pros and cons of various approaches?
Look, at the outset, remedies were simpler. You misrepresented something in your privacy policy. It was a general don't misrepresent prohibition. And that was pretty consistent in the data security area as well. It was a general establish a reasonable program, establish the appropriate parameters. That was pretty well established. I think things changed after the LabMD decision. At that point in time, we had, Maneesha, it was the 11th Circuit, right?
Yes.
We had the 11th Circuit looking at an FTC order and saying it lacked the specificity that was required to make it enforceable. At that point, the FTC did change its orders quite significantly. It started making them far more robust, more specific, and more enforceable. So certainly on the data security side, we've seen that evolve even more, where the orders are just getting a lot more specific and more granular over what the expectations are in terms of having reasonable security going forward, whether it's specific provisions about encryption or MFA or things of that nature. The orders are just far more prescriptive than they were a decade ago. And I think is continuing on the privacy side as well, where, again, rather than just have general provisions, don't misrepresent how you share, collect data, more limitations on how data is being collected, what it's used for. So we're definitely seeing orders becoming far more prescriptive. And on a specific company that has violated the law, I understand. And I understand that there's a need sometimes for more specificity. Question becomes, can you take those generalized provisions, those specific provisions that have been used with respect to a company that's allegedly violated the law and apply it more broadly? And I think that's a little bit of what we're starting to see. There's a shift from company violated the law. They're now subject to a more rigorous order to, are we going to incorporate those more rigorous provisions to the industry writ large, to the economy writ large? And we're seeing some of that possibly in the commercial surveillance rulemaking, certainly. But no, the orders have clearly gotten far more rigorous, far more specific, and more enforceable as a result. That is an important criteria, should be.
I'm just going to add to that briefly. I think on the privacy side especially, and you're right, data security, there's a longer lineage here on security programs in our orders. On the privacy side, one of the things, and I alluded to this earlier, that our chair has said, other commissioners have said, and I have said over and over again, is that notice and choice, which has been the prevailing regime for decades in the absence of a federal law, is not working. The notion that consumers are going to read thousands of pages of privacy policies, the notions that they're going to understand it, companies' ability to change these privacy policies at will, the lack of choice in many marketplaces, the inability for many consumers to opt out of the digital economy. All of these factors, in my view, have made notice and choice a fiction in the modern economy. I think there's consensus around that, but I think FTC leadership in this moment is stating that very explicitly. And what flows from that is a different approach. It has historical lineage, certainly, but an evolved approach to some of the remedies we're seeking. Specifically, what we are really looking for in a number of our orders is substantive safeguards for people's data and a number of actions like GoodRx, BetterHelp, Premom. We didn't just require companies to get consumers' consent to share sensitive data. We prohibited companies in those orders, they were all consent orders, from sharing sensitive data for advertising purposes. I think in half a dozen cases now, we've gotten data minimization requirements in our orders. In our Epic Games matter, we required the company to change its default settings to make it more privacy protected. So we're really trying to put our money where our mouth is and recognizing that just disclosures and checkboxes are not doing enough to protect people's privacy and working to translate that into real protections for people's data.
Do you think with the tools that it currently has at its disposal that the FTC will be able to keep pace with the scale of technological advancement that's posing larger threats to privacy and address all the harms that come from various invasions of privacy?
I think we've talked a lot about the limitations of the FTC's authority, but I think there's a beauty in the fact that the FTC has hung its hat on this phrase, unfair or deceptive acts or practices, and I think the beauty is that you can use that phrase to keep up with advancing technologies. And so again, as I mentioned, infomercials, telemarketing, internet, now AI and other technologies, crypto, there's a lot of things that the FTC can do with its authority. One of the interesting things in the 2010s in the Wyndham litigation is that the company challenged the FTC saying that the unfairness authority cannot possibly extend to unfair data security practices because that's a huge part of the commercial economy. And quote, Congress would not hide elephants in mouse holes. And the FTC won that case, or at least won the motion to dismiss, and including on the Third Circuit, where the Third Circuit validated the FTC's ability to go after unfair practices. And it cited to the fact that Congress perfectly intended for the FTC to find new unfair practices and not freeze the types of unfair practices that were going on in the early 20th century when this law was passed. And so I think that's one of the beauties. And so I do think the FTC can keep up. I know they've hired more technologists. They're working on these issues. But at the same time, I think there are a lot of constraints on the FTC. We've talked about the resource constraints. We've talked about some of the legal constraints, inability to get fines for first-time violations, et cetera. But I think there's also some political constraints on the FTC. So every time the FTC doesn't do something that one of the members of Congress doesn't like, they get hauled in front of Congress for hearings. And so I think that there are some political constraints. Maybe it hasn't constrained the FTC into action, but they do have to have some accountability to Congress for those. And so I think those are some constraints. And I think we all agree that a better approach would be specific federal legislation on privacy that gives the FTC specific tools that it could exercise. And I think that's something that is probably not going to happen in the near future. And so the FTC is going to have to continue doing what it's been doing.
Yeah. And I think a follow-up on that, you have to think about all of the policy work that the FTC has done in this area, the workshops that have been held, the reports on cutting edge issues. The FTC does a really good job of keeping up with what is happening in the economy, with technical innovations, whether it's the facial recognition report from 10 years ago, or even more than 10 years ago. There's just so much the agency is looking and exploring, both through inside and outside experts. Certainly the hiring and ramping up of technologists in the building has been certainly noticed, but it's a really good thing. The world is far more complicated and the agency needs experts and expertise to address these issues.
I totally agree with what Daniel and Maneesha said. I'll start with the pessimistic note and end on an optimistic note. We're vastly under-resourced. We talked about that already. I do think we need stronger tools, including first-time fining authority. I think our country desperately needs comprehensive privacy legislation. There's a lot that we need and a lot of challenges that we're facing. But I think we will continue, as we have for many years, to punch above our weight and to be a really nimble, and in some way, as Maneesha said very well, the fact that we're relying on UDAP confers an advantage in the sense that it does allow us to be more nimble. If you look at how AI has become the hot topic of 2023, we've been able to move very quickly at the FTC to lay out how we believe Section 5 applies to new uses, for example, of generative AI. We've been able to lay down some clear markers, I think, faster than other agencies across the world. We've even been able to bring cases, as we did just 2 months, last month, against a company called Automators AI. So we can move really quickly. We have really good people, best private, as Maneesha once said, the best privacy lawyers in the world. We have an incredible stable of technologists now and a growing stable of technologists. We desperately need more resources. We could certainly use more tools, but I would not count us out. We've proven nimble for a century and we'll continue to do so.
And I want to underscore how important and significant it is that the FTC is ramping up the hiring of technologists. So many of the future threats to privacy are occurring in the online space that having people who can actually understand codes and algorithms and be able to identify problems in them makes a huge difference, in my opinion, in terms of the FTC's ability to understand what they're seeing and identify problematic areas. It's no longer just an agency of lawyers and economists, but truly the expert agency that was originally conceived when Congress founded it 100 years ago. So in this episode so far, we've talked about the past and present of FTC privacy enforcement. And I want to talk a little bit now about the future. We talked about federal privacy legislation. And I just want to give a little bit of background here. I was on Capitol Hill, I think one of the last times that the Senate took a hard look at federal privacy legislation. And all the senior Senate Democrats whose committees of jurisdiction had some privacy law to enforce were tasked with trying to come up with a framework. And so Sherrod Brown on financial services, his team had a privacy framework, and Maria Cantwell on commerce, her team had a framework. And I was on Feinstein's staff in judiciary, and we had a framework. And one of our sticking points was no preemption of the California Consumer Privacy Act unless the federal law served as a floor. Well, that had to be the floor. There's no state preemption. And if you have two members of your delegation who are not going to allow for preemption of state law as part of a privacy law, unless you incorporate their state law, which I think was either that or Illinois is like probably the first state level privacy law. Federal privacy legislation may continue to be this dragon we're chasing. So is the future of privacy in the U.S. at the state level?
Yeah, so actually, and I think of like, when I think about the future and what's going to happen in 5 years, I think there's a tale of two cities, so to speak. I think the one kind of utopian vision is that Congress passes federal privacy legislation, gives the FTC additional tools and resources, and the FTC is off and running. State AGs are also involved in privacy. And I think that's the vision one. I think vision two is Congress doesn't act. Companies continue to litigate against the FTC, strapping their resources even further. There's resource constraints. I think you have a situation where you see state privacy laws come to the forefront and really states taking more of a lead role on privacy. I don't think any of those two extremes are going to happen. I think right now we're seeing states exercise more primacy and privacy than they have in the past, enforcement in California and other states. But I wouldn't count the FTC as out just yet. I do think that the FTC continues to have sway, and I think companies are continuing to ask, what does FTC do and what does FTC compliance look like? It'll be interesting to see how that unfolds.
Yeah, it's certainly, look, when you look at the patchwork of state privacy laws that have developed and are going to continue to develop, this is a source of frustration and challenge for a lot of companies that are wanting to comply with the law, but now are certainly seeing that a broad federal privacy comprehensive law would be far easier to comply with than a patchwork of state laws. But that said, whether Congress can actually get there, very big question and very unclear.
Last question for this group. If Congress were to enact privacy legislation, is the FTC the right agency to enforce it? Or should they consider setting up a standalone agency with new personnel, new experts, new lawyers, similar to how the Consumer Financial Protection Bureau was set up in the wake of the financial crisis?
So I can jump in on that. Let me start by saying it's urgent that Congress pass. It's been urgent for a long time that Congress pass privacy legislation. At the end of the day, it's up to them what that legislation looks like. What's most important is that Americans' privacy, that their data is protected. All of that said, I do think there are a lot of advantages to having the FTC continue its role as the country's primary privacy enforcer. The fact that we have expertise across markets, our jurisdiction at the agency spans almost the entire economy with very few exceptions, is actually a huge advantage. Maneesha referenced do not call. For a long time, and increasingly now, we see privacy issues in our fraud work. We see privacy issues in our financial services work. We see privacy issues in our work on lead generators. We see privacy issues in our work on telemarketing. Across the board, we have expertise in the markets in which privacy matters most and in which privacy laws have the most impact. And I think that gives us a huge advantage. I think siloing privacy away from other consumer protection enforcement priorities does have drawbacks that I hope Congress takes into consideration. I think we've proven to be a very effective enforcer. I think we've proven that we can leverage our expertise across markets to strengthen that enforcement. I think we've proven very good at staying ahead of issues and delivering some of the timely market reports that Daniel referenced as well. So again, I first and foremost want Congress to pass legislation, but I hope that there is a recognition of the unique advantages the FTC brings to the table, to say nothing of our competition mission, which could be the subject of a whole other podcast.
Well, can I just add to what Sam said? I think that he said it beautifully, and I agree with everything he said. And I think that in particular, having privacy and competition in the same agency is really a plus for the FTC. And also privacy and advertising. So I think hopefully we'll get to a world where companies start competing on privacy. They start advertising their privacy efforts. And so I think that having that expertise in both competition and advertising is a great underpinning, and I would hate to lose that.
Yeah, and I would definitely agree with what they're saying. And I have to say, as someone who spent many years at the FTC, and I was seeing sort of federal legislation that will require the FTC to create a Bureau of Privacy, A, it's the right thing to do, but B, I look at that and wow, that would be really exciting and fun to do. And there are really talented people at the FTC that would be able to very successfully and quickly also build a highly functional Bureau of Privacy that was able to do all these things, the enforcement, the rulemaking, because of course the statute comes with a lot of rulemaking responsibilities, and really kick it off rapidly. From my perspective, it would be a mistake to task this to a startup agency.
Let's end with some takeaways for practitioners. Maneesha, let's start with you.
I would just say, pay attention to FTC guidance. Make sure that you're reviewing your claims on privacy, because even though they're focusing on unfairness, I think they have to use their deception tools as well. And make sure that you're conducting risk assessments and assessing where your practices could cause harm to consumers and reasonably addressing those.
Daniel?
Yeah, and I would say think about unfairness, because that is the tool that the FTC is going to be using for some of the more sort of creative areas where we're seeing FTC enforcement and rulemaking. Are your practices potentially unfair? And it's a difficult standard to assess in some situations.
And Sam?
I would just say we've touched on some of the controversies around the FTC, and there are more that we could talk about. But I hope people realize, as all of us, I think, agree, there's a lot of consensus around the need for stronger privacy protections and the important role that the FTC plays in that. There's bipartisan consensus across Republican and Democratic commissioners. There's consensus among state legislatures and the federal legislature. There's consensus among Congress and the FTC that we need privacy legislation. And as I said, there's consensus in this group. So for all the noise around edge questions around rulemaking or unfairness, there's a broad consensus that we need stronger privacy protections and broad support, I believe, for the work that the FTC is doing to better protect Americans.
Thank you, Sam, Maneesha, and Daniel, for this fascinating look back at the first quarter century of FTC privacy enforcement. To our listeners, be sure to subscribe on your podcast platform of choice, and we'll see you next time on Trust and Trade.